Well, welcome everyone to this presentation. Chris and I are very excited to present to you for the next hour or so, talking about experts, how to work with them, and some of the fundamentals in medical malpractice claims. I'm just going to get my screen working now, so one moment. And I'm going to start my slideshow. Is that working for everyone?
That's perfect. Thank you, Paul.
Okay, good. So I'm going to talk probably for about 25 minutes or so about sort of the fundamentals that you need to think about when proving a medical malpractice claim, and talk a little bit about experts before I turn it over to Chris to talk to you guys in more detail about working with experts and her presentation. So just to tell you a little bit more about myself and my daily practice. So I'm at Will Davidson. We have 18 lawyers in 5 offices across Ontario. Our principal focus is personal injury and insurance litigation. My practice myself is predominantly, I'd say, medical malpractice, plaintiff side only. So about half, a little bit more than half of my cases are medical malpractice claims. And I've been doing that pretty much since I started practicing law. I've always had a focus on medical malpractice matters. The other part of my practice is what I'd call just a general plaintiff side personal injury practice. So I do car accidents and slip and falls and long-term disability claims. In my typical day, I get a lot of phone calls from potential new clients. You'd be surprised or not at how many people are quite unhappy with our healthcare system. Some of their complaints are 100% legitimate, and some you could call trivial, but there's no shortage of people who are concerned about the care that they received in a hospital setting or from a physician, and they are online and they're finding lawyers to talk to about their cases. So in my typical day, I usually get at least 1, sometimes 2 or 3 potential new client intakes that I either deal with or I delegate off. The other thing that I do in a typical day is communicate with health professionals. In fact, just before this call, I was on the phone with an ophthalmologist on a particular case. I'm always trying to get reports generated or getting preliminary opinions on cases. So my calendar is quite full with meetings and calls with experts to learn about the medical issues of a particular case and learn if the case that I have is worth pursuing. So that's my typical day. I'm going to talk a bit about proving a medical malpractice claim and the great challenge in this area of law, which is finding experts. So just some basics, and I'm sure many of you know this, but particularly those who practice in civil litigation, the burden of proof in a medical negligence case is on the plaintiff. Like all civil claims, it's on the plaintiff. But it's important to keep that in mind, that you really do have to prove your case, and it is a balance of probabilities, but they're so challenging, these cases, that you really want to understand that you need to get the evidence, you need to get the right experts, you need to have them say the right things, because if you don't, your case is going to get dismissed. And the CMPA, the Association That Defends Physicians, they're very aggressive, they understand the law, they're very skilled and experienced, and they know if you have not met your burden, and that is a defense that they will certainly use. Duty of care, obviously there has to be a duty of care in the context of a lawsuit from the defendant to the plaintiff. Usually not really an issue in the vast majority of these cases. Standard of care is critically important, and one that you typically would rely on expert evidence to assist with. The standard of care is what a reasonable, prudent physician with similar training and experience would have done or should have done in the circumstances of your particular case. And I'll talk a little bit about some specific cases towards the end of my my presentation to give some grounding into that. But that's what the standard of care is. It's not a standard of perfection, but it is what the standard, what a reasonable, prudent physician would do. Causation is another important element in these malpractice cases, probably the biggest area where there's challenges and dispute. which is quite different typically from your general personal injury cases, where you'd have a client who might have a slip and fall and they might break their arm. You're not really thinking about causation. You're more focused on standard of care. In medical negligence claims, causation is probably the strongest area for defending a particular claim, and then damages, obviously. Speaking just specifically about standard of care, and I'll talk about causation in a little bit more detail as well. Standard of care is ultimately up to the trier of fact, so it is a factual inquiry. When you're proving a medical negligence claim, you need to have the court accept what you say the standard of care is. That means that you need to have an expert testify as to what should have happened at a particular time, and then you need to prove that that didn't happen, or there was a breach of the standard of care. The standard is reasonableness, not perfection, and you can certainly see the challenges sometimes when you look at a case and you see that a patient had a particularly bad outcome, and you might even, as a layperson, see issues where it just didn't seem like things were done properly. For instance, there's, I don't know, an 8-hour delay where the person was sitting in the waiting room in an emergency room and wasn't seen, and then they deteriorated and some bad outcome happened. You might be looking at that and say, well, that seems like an awful long time for somebody to wait in the emergency room. That's got to be negligent. It might not be, depending on the factual circumstances of the case. An 8-hour delay might be reasonable given the person, how they presented, and the circumstances of the emergency room on that day. So when we look at cases, we have to remind ourselves that we're not looking for perfection. We're looking for what's reasonable, and reasonableness includes certain delays or maybe decisions being made that ultimately weren't the best decision at the end of the day. When it comes to having your expert testify as to the standard of care, they need to, and if they're talking about the defendant's standard of care, they need to be the same kind of expert, right? And it makes sense. You're not going to have a neurologist come and testify about how bad the emergency physicians were by not diagnosing some neurological condition in the emergency room and referring more quickly. I mean, you can do that. You can try to do that, but you're going to find that the court's going to say, well, hey, wait a second. What does that neurologist really have to say about the standard of care of an emergency physician? That person doesn't practice in that area. They don't know what it's like in the emergency room. They're not really qualified to give that opinion. And it does get challenging in medicine because there can be overlap of specialties. Physicians often work, particularly in hospitals, in a team setting. So you may have multiple physicians of different disciplines all working on a similar case. So to some extent, they would have some understanding of the roles and responsibilities of other people in that team environment. But to have them come and talk about the standard of care for a particular discipline, you really need to have the person with the same experience and the same standing, so to speak. The focus is on the care that's provided, obviously, not the result. So, as lawyers, we hear these horrible outcomes. People lose their legs or whatever happens, and or die in the hospital, and the family's obviously very upset. But we need to be a little bit dispassionate and just focus on the care prospectively, not retroactively, because that's what the law requires us to do. An error in judgment is not negligence. So physicians have to make decisions. And I'm going to just jump into a case example on this judgment issue, because it can actually become quite challenging. And as a matter of law, if the doctor makes a reasonable decision and exercises clinical judgment, and it turns out to be not the best outcome, they won't be found civilly responsible for that. So I have a case, an interesting case, where a man in his 50s, he had kidney cancer, and he had a nephrectomy, so he had his kidney removed that had the tumor in it. And they did some post-op tests just to make sure that he didn't have cancer anywhere else, and that included doing a chest X-ray. And they found some suspicious-looking nodules on his chest. And so he was referred to an oncologist to look at that specific issue, who thought it was lung cancer, although it might have been something else. It could have been a treatable lung condition called sarcoidosis. The oncologist said, well, I'm not really sure about this. I'm going to send him to a cardiac surgeon to do a biopsy. And then we'll get a biopsy, and then we'll know for sure whether it's cancer or not. So the gentleman gets sent off to a thoracic surgeon, who says, I don't think I really need to do a biopsy. It's like almost certainly cancer. So there's no point. It's a waste of time. And so the gentleman gets sent back to the oncologist, who then starts this man on some pretty strong cancer-fighting medication, chemotherapy, radiation therapy, and so on. And it also tells him, unfortunately, sir, you're not going to live very much longer. You might want to get your affairs in order. A year and a half goes by, and he's still getting all this treatment, and he's still alive. And somebody at some point says, well, that's a little strange. Maybe we should look at that lung again. And they look at it again, and this time another radiologist says, well, I don't think that's cancer. And they end up doing a biopsy, and they discover that, in fact, this man did not have cancer. It was this other condition that could have been treated. So this is a case I'm handling right now, and I can anticipate that the defense will probably be that that was an exercise of clinical judgment. Here's a person who, by all accounts, looked like they had cancer. A biopsy does come with certain risks, and so the thoracic surgeon exercised clinical judgment by deciding not to do a biopsy. So those are the sorts of challenges you might come across. I personally think that in such a case like this, before you start treating someone with cancer medication and telling them that they're terminally ill, you should probably know for sure that it's cancer, and the only way to do that is to take a biopsy and test it. However, I could see an argument being framed that, no, this was a reasonable decision that was made. It wasn't the right one, unfortunately, but it was reasonable in all the circumstances. So those are even in cases where they seem pretty straightforward, you can have these sorts of defenses. Okay, so I'm going to move on. The legal test, as I mentioned earlier, is what would a reasonable and prudent physician have done in the circumstances of the particular case. So that's something that you would be having your expert comment on. You obviously have the burden of proving this, so you need to make sure that your expert report clearly articulates what that standard of care is and how the defendant physicians or nurses fell below that standard of care. Where the only time you really don't need to have an expert, although it's generally good to always get one, is where the negligence is so obvious that a layperson would know. So classic would be wrong-sided amputation or wrong-sided surgery, where they just operate on the wrong part of the body. I don't think you really need an expert to say that that was negligent. We know that from common experience that that's negligent. I have another case where I think would probably fall into this, and this is a case where a gentleman had end-stage kidney disease and required dialysis. And as you probably know, dialysis involves basically taking blood out of your body and cleaning it, so to speak, and then putting it back in your body. So this man was having his dialysis done, and unfortunately, someone forgot to basically plug him back in. So he had a lot of blood coming out, but not back into his body. In fact, the tube or whatever it was supposed to be hooked into him was on the floor or something like this. And so when they came in, they hooked him up and left him and came back about an hour later, he was basically had died, and there was a pool of blood on the floor where he basically lost all his blood. So a tragic outcome for him and certainly his family. But when you look at it and you wonder, well, what sort of expert do I need? I mean, obviously you could get, a dialysis nurse or a nephrologist or somebody to comment on it. But when you really think about it, it does seem like it's common sense. But I think generally you do need to be careful, despite some cases seeming very strong. The burden of proof is still on you. And if the court determines that you still need expert evidence to prove your case and you don't have one, you'll have a problem. Causation, generally it's the but-for test. When you deal with experts and you talk to them on the phone and you're trying to get them to write a report, I find they often have a hard time understanding causation, and I think a hard time understanding what the civil standard is the balance of probabilities. So that's absolutely something you need to talk to your doctors about when you're writing reports, because if you don't, you're going to hear them say things like, well, I don't know for sure whether, this outcome would have been better, so I can't really say that he would have had a better outcome if such and such happened. Or it's impossible to really know what would have happened because it didn't, this test wasn't done, so we just don't know. Physicians are scientists, and they're also, when it comes to law, they're lay people, and so they can kind of bring about one of two sort of biases, I think, to the table when you're talking to them, and one of them is misunderstanding that the standard is more of a criminal standard. So they think that, well, I need to, be certain beyond a reasonable doubt to say anything that might be supportive of a causal connection in a case. Or they just apply their own scientific standard, where if, they can't say with scientific certitude based on peer-reviewed journal articles that they've researched and so on and so forth, then they can't really say that. So that's always the biggest challenge, and often you're fighting over words where most experts, physicians, when you see their first drafts, they are much more comfortable saying things like, if such and such happened, it might have made a difference, or it could have improved the outcome, or it's possible that with such and such medication, the infection would possibly not have developed to be so severe, because they're more comfortable using those words because they're a little bit less strong. Unfortunately, wording like that doesn't help a plaintiff in a civil lawsuit that you have the burden of proof to prove the case, but you're also being challenged vigorously by opposing counsel and their experts. So you need the expert to be a little bit stronger on the words they use. A lot of that really just comes down to education and explaining to them what the but-for test means, what the civil standard is. It's 50% plus 1, that they can use words like probably or would likely have and still meet that legal definition. And if they really have a hard time understanding, I do make sure to take a lot of time to explain that to them, because it really will affect their opinion if they have a misapprehension about what the law is and what the civil standard is. So as I was saying, it doesn't require scientific precision, and it doesn't have to be the sole cause. So the other challenge often is, when we're dealing with medical malpractice cases, you have to remember most people who are victims of medical malpractice were at the hospital for some other reason that had nothing to do with the medical malpractice. So people are going to the hospital because they're sick, because they're in distress, because they have a medical condition or medical conditions that cause them to need to be hospitalized or seen by a physician. So, it's not like a car accident where people can be perfectly healthy and get severely injured. Generally, people who are going to the hospital, for the most part, with some exceptions, such as, babies being born and so on, but people going to the hospital are, already sick. So you have to try to figure out what effect of the malpractice has had on their outcome versus what they already had. And I have another example, a case of an older woman who was found in her home by her daughter, and she was very, very sick and not doing well. She's in her 60s, and she gets taken to the hospital and they start intravenous lines, as they would. And one of the nurses, it appears, didn't flush the line and ended up putting air into her vein and causing an air embolism. And that actually got into her brain and caused a brain injury, which is horrible and shouldn't have happened. The challenge is that this woman, it appears, already had some kind of cognitive problems related to the episode that brought her to the hospital. So the challenge in a case like that is going to be understanding how much this air embolism caused damage to her brain and affected her functioning versus what she already had. Okay, and then that challenge is obviously something that you need assistance with experts with. The practical reality of medical malpractice litigation is, in my opinion, is it's one of the most challenging areas to practice in. It's one of the most challenging areas to practice in because you're always met with a vigorous defense. You can guarantee that with some rare exception, you open up a medical malpractice case, it's going to be with you for 6 or 7 years. You're going to go through discoveries, you're going to go to a pretrial or multiple pretrials, and you're probably going to go to about a week or so before the trial, before the case might settle. Sometimes you get lucky and cases resolve a bit earlier, but generally no cases are resolved until the association, the CMPA, has had a chance to look at everything, explore all possible defenses, consult with probably multiple experts on the other side to see whether it's a defensible case, and if they determine that it is defensible, and there's all kinds of ways that it could be, they then put up the brick wall and they say, we're not paying any money, you'll have to go to court. And as I was alluding to earlier, the cases do take a long time. They take a long time because partly the civil justice system takes time to get to trial, and cases tend not to resolve until closer to trial. So the resolution point tends to be later on in the course of a case. And the other thing is experts take a while to get reports. So nobody's really going to want to talk to you about settling a case until you produce expert reports, and often you need more than one. And sometimes you need one before you can get another one because the opinions are interdependent on each other. And experts, some are good. They can draft a report in a couple of weeks, most a couple months, some up to a year. And you got to chase them down and harass them a bit and try to get them to write the report. But the reality is that it can take a long time. So you throw that into the mix, and you probably don't want to set your case down for trial or ask for a trial date or pretrial if you don't have all your expert reports in hand. There's often a big kind of time, I wouldn't call it a delay, but a period of time where expert reports are being developed, post-discoveries that can take a year or more just to get that done. And discoveries can take a while to get organized as well because physician schedules as defendants can also be challenging. Cases are really done on a contingency fee basis, which means there's a lot of risk on the lawyer, a lot of time gets put into them. Again, using the example of a motor vehicle accident case where, for the most part, well, these days less so, but for the most part, if a person has objective injuries from a car accident and it's not their fault, the case is going to settle. It's just a question of when and for how much. You don't know that in a medical malpractice case. You really don't. It might not settle. It might have to go to court. It might go to the Court of Appeal. And you certainly do have to put a lot more work into the cases. So they're much riskier. The disbursements are much higher. Often you're spending $5,000 or $10,000 at a very preliminary stage just to figure out if you have a case. And once you go to getting full reports on even a straightforward case, you're usually at $25,000 or $30,000 in disbursements. And then, of course, if you go to trial and you need to get your experts to come testify, you could easily be into 6 figures. The cases stand or fall on the opinions and testimony of third parties, the experts. So despite what you might think or what your client might think, despite what the judge might think about your case or a jury, it really is all about the opinion of the expert. And only will you win if you have a good opinion from a good expert, the judge, jury accepts, only then will you win your case. And so you're often very dependent on them, which can make you a bit nervous. They might not stick to what they say in the report, or something might happen, an intervening event might happen so that they're unable to testify at court or something like that. But that's the practical reality of it. So I think I kind of went over all this and kind of starting to transition now into Chris's presentation, but finding an expert is hard. Finding the right expert is even harder. So it's one thing to be able to find someone to look at the case and charge you for it, that you can kind of do, but you need the right expert to give you the right opinion. Otherwise, you're going to find yourself at trial. And hopefully that won't happen. So that's the gist of my presentation. I hope that's been informative. Before I pass it on to Chris, does anybody have any specific questions for me? I think you can type them into the chat screen. Or Chris, if you have any questions.
I have a question for you, Paul, before I rip into my presentation.
Excellent.
Once you have found a good expert or someone that you're happy with,
yep.
What are your biggest challenges of working with them?
So I always, this is funny. So I always get worried about how they're going to perceive the civil standard of care. And I find, particularly with experts who haven't done a lot of medical legal work, which I like to work with those people because I find, you know, they can't be accused of being a paid, you know, a paid advocate or anything like that. And they have a lot of clinical practice and they're, you know, all that. But the concern I have always is, you know, are they going to be wishy-washy about things because they want to be, you know, kind of fair to everybody and they don't want to overstep what they think they can say. And I find that can be a great challenge. I even have, you know, cases. I had an expert I consulted with once who prepared a report and said, "Oh, can you not use my name on the report? Can you just send it anonymously?" And I said, "No, like I can't do that." He said, "Well, I just don't want anybody to know that I wrote this report." So, you know, when you have people who, you know, experts who come very timidly into the arena, so to speak, that I find can be frustrating because it's hard for me to do my job if I have that sort of report. And I think what frustrates me the most is I think it comes from a misunderstanding or misapprehension as to what the civil standard actually is. And for that reason, they kind of tone things down because of fear that they can't, you know, give you convincing evidence on a, you know, beyond a reasonable doubt or something like that. So that I find is the biggest challenge with working with experts.
Really interesting. Very interesting. And understandable, knowing experts as I do, understandable that that's a challenge for them. And I'll try to talk a little bit about more about that. Okay.
Okay, well, I'm done.
Should I just move on then?
Yeah, go for it.
Okay, sure. Well, I'm Chris Rokosh, and I'm going to spend a couple minutes talking, first of all, about Connect Medical Legal Experts and the services that we have to offer, who we are, what we do, how we do it, why we do it, processes and fees. And I'll run through that quite quickly and happy to answer any specific questions about that. But then I'd like to share with you what I think is some really fascinating insight into the personalities of some of the most frequently used medical experts that we get requests for. Medicine is practiced by a lot of different people in a lot of different ways who have significantly different roles. So, and I think it's well accepted within medicine that different kinds of people are attracted to different kinds of expertise within the medical field. So I've always found it really fascinating, and I'll share some of that with you. We'll talk about surgeons and surgical specialties, obstetricians, working with neurologists, working with ER docs who are mostly general practitioners and family physicians, and then talk a little bit about working with nurses as experts as well. The goal of sharing this information with you is, number one, I find it fascinating. I think it's really interesting. And the second is to be able to, once you find the expert or we connect you with an expert, to be able to get the best out of them once you found them. So talking about my company, we started in the year 2001. I started by doing a single case as an expert myself, a labor and delivery case that had a bad outcome. And as I was new to it and it was scary for me, and everything you just described, Paul, was very much in my own thinking and psyche. It was very difficult for me. I remember the first time I typed those words in a report that it was my opinion that the nurses hadn't met the standard of care. That presented a huge kind of moral and ethical challenge for me as, you know, I've been part of a team of nurses my entire life. And I've since learned a lot more about the law, but I certainly appreciate what you're talking about, the challenge with experts. And I think as lawyers, it's important for you to understand that, and well, helpful for you to understand that, be able to talk to the experts about that. But from that point, lawyers said exactly what Paul said. I said, how did you find me as an expert? The lawyer said, I had a hell of a time finding you. And I thought, well, there we go. I can help with that. And that was the beginning of my company as I know it now. We have 200 plus experts working every single day, and we have medical legal support and education in Canada, US, Australia, some in Europe and in the Caribbean. We've done thousands of cases for hundreds of lawyers, lots of medical records for large-scale class actions. Our experts are from all across the country in all areas of expertise. The philosophy behind our company is, as was described in my opening intro, I really believe that the open sharing of knowledge makes us all better, and that medical knowledge can improve or support legal outcomes, and legal knowledge can improve and support healthcare. So everyone who works within the company, we're all healthcare professionals, minus the IT guy. We're willing to share our expertise. We pride ourselves on, as a company, excellence and innovation, and as experts on quality, a lack of bias, diligence, and defensibility. We're not perfect every time, and certainly there are challenges connecting the right experts with lawyers. And even the perfect person on paper doesn't turn out to be the perfect person in reality. But we try hard. That's a goal. We work with some of the biggest law firms in the country, both plaintiff and defense firms, and also in the US as well. We've just had the honor of being voted for the second year in a row Canadian lawyers' favorite medical legal expert witness company, and we're proud of that. That just happened a couple weeks ago. Our experts, you know, as I said, medical expertise is really at the core of our business. We provide healthcare expertise to plaintiff and defense lawyers, insurance agencies, once in a while to criminal law. We currently have a contract with the Department of National Defense, doing some work with them on a couple of their cases that need some medical expertise. A lot of class action work, as I said, both in Canada and the US. And my part of giving back to healthcare is to share the lessons I've learned from lawsuits to educate healthcare professionals on way to improve patient safety. In the last couple of years, I've talked to 7,000 or 8,000 nurses on medical legal issues in nursing. And because it seems to me that in the cases that I reviewed, some of the same issues just come up over and over and over again, and they're often around assessment and communication and skill level and medication errors and equipment errors. So, you know, I'll go to nurses and say, listen, stop doing this. You know, these are some simple lessons, and just take some basic diligence that can be overcome to improve patient safety. And that gives me a great amount of satisfaction as a healthcare expert and a healthcare professional myself. We work hard, as Paul said, to not just find an expert, but the right expert for every case. And sometimes that means going through 20 different experts to find one who says, yes, I have that clinical experience and expertise. Yes, I feel comfortable providing opinion. And that can be quite challenging, but also challenging in a good way for us as the locator of the experts. We find fun in that. Because we're all healthcare professionals, we are also, you know, we're very active socially, mentors, teachers. Some of us are entrepreneurs, but we do all have a very strong sense of educating and promoting patient safety. And our sense of responsibility, both in our clinical expertise and our role as a medical legal expert, is really based on the belief that what we do is important. I spend time with all the experts that we work with, impressing upon them that their role in providing an expert opinion in a medical malpractice case is a huge responsibility, and providing them with the understanding that the outcomes of lawsuits affect patients and healthcare professionals, public funding, our social systems, our institutions that provide healthcare, other doctors and nurses, the families. So we try hard to impress upon them that all of their work must be unbiased and defensible, credible. Watertight opinions is the best that they can be, accurate and complete. We also try to impress upon them that their work as an expert is dependent on quality work delivered in a timely manner. And certainly it is a challenging working with a busy orthopedic surgeon to get them to write a report within a reasonable period of time. But we certainly try for that. And we also impress upon them that once they decide to take on a case and step in to provide assistance, that they're in it for the long run. There's no quitting, there's no backing out if the trial shows up, there's no stopping at some point because you retire or get too busy. But unless something serious comes up that is unmanageable for the role as an expert, we request and we require of them that they're in it to win it, or not to win it, but in it to the end. We're also involved as a company, thanks to our healthcare experts and the lawyers that we worked with across the country in many different charitable healthcare efforts, and really appreciate that. One of the funnest ones we're involved in is a project in Jamaica where both doctors and lawyers have provided free expertise for victims of medical malpractice lawsuits in that developing country with a very challenging healthcare system. Our capabilities as a company include a single witness for individual claims or multiple expert witnesses for individual claims. You might need a nurse, a physiotherapist, an orthopedic surgeon, and a neuropsychologist, and we're happy to locate all of those. If there's concern and you're just wondering if you have a potential case, we're very happy to find the right expert to do file reviews summaries for a reasonable price to just give you an idea of merit or issues and the potential players of the case. Class action, cost of future care assessments and reports. We have a couple of nurses who are very well qualified in medical record translation, French to English, and we do lots of education, both to lawyers and experts. Our process is hopefully quite simple. You can request an expert through us. That can come by phone or email or a letter or fax. Sometimes just boxes of documents show up on the front step of the office, and there we go. We'll get the information we need to clarify on any potential conflicts of time and interest, and to be sure that we can briefly discuss the case with the expert to assess their own assessment of their qualification and ability to provide expertise. We then connect you directly with the expert, and we step back unless there's issues or resolutions, and we don't. So you work directly with the medical expert unless you need some help. We do offer lots of background support if it's needed. We can provide administrative edit of the report. We have a medical researcher. We have nurses of all different areas of clinical expertise who could develop chronologies if that helps support the physician expert. And then we don't step in again until it's time for invoicing at the very end of the case. We've talked to a lot of our experts and said, what do you need from lawyers to help you do your job? And they all appreciate lots of communication back and forth, involvement in a case as early as possible, a complete set of medical records and transcripts if you've got them, basically having as much information as possible for them to be able to develop a really thorough, unbiased opinion. If it's an IME, which we don't do a lot of, but we do them occasionally, enough information to perform an in-person assessment if that's required. They always appreciate well-organized records, and generally that's not an issue, but every once in a while, you know, someone will get 7 boxes of loose leaf paper, which is a challenge and pricey at the end of the day to put together from the lawyer's perspective. And they always also appreciate timely requests, recognition that they're busy professionals, and occasionally we can pull off an expert opinion within days or a couple of weeks, but generally they appreciate a couple of months. Pricing and costs. Our nurses and allied healthcare professionals, meaning occupational therapists, physiotherapists, midwives, diagnostic imaging techs, start at $200 an hour. Our physicians for plaintiff lawyers will set their own rates. CMPA rates are currently sitting at around $375 an hour. And so for defense cases, they often will stick to around that rate, but many of our physicians start on the lowish end at $4 and go, I'd say most of them in the $400 to $700 an hour range. Occasionally it's higher, occasionally it's a little bit lower, but it's expert dependent. We let them set both their trial and hourly rates. Our nurse life care planners start at $175 an hour, and that's for a cost of future care report. An average report for us falls in a $3,000 to $7,000 range. Sometimes they're, just $1,000 or $1,500, and sometimes they do run 10 to 12, depending on your needs, on the amount of documents, on the amount of research or planning that needs done, and the expert themselves, and your own requirements for the report. And I'll just maybe stop there talking about the company, but please, if you have questions, type them in and I'll be happy to answer them at the end. And move now on to talking a little bit more about the experts. So as you now know, I've had the opportunity of working with lawyers and experts across the country. And a couple of years ago, I just started to wonder, when lawyers do have some challenges working with experts, whether it's getting their report on time, having them understand the legal causation test versus a medical causation test, those kind of issues. I sent out a survey to 200 of our physicians and asked them some really specific questions, like what would you like lawyers to, how can lawyers get the best out of you? What would you like them to know? And I put together that information and presented it to the Alberta Civil Tort Lawyers Association conferences a few years ago, along with the lawyer. And I've summarized some of that information as well as tossed in some interesting psychology, which I hope you're going to find really interesting. Please note that the work that I do within my company is almost exclusively medical malpractice. We don't do a lot of personal injury or IMEs. So the type of experts that we get requests for may be different from your personal injury work. But over the last 10 years, we've given thousands of opinions. And from the nursing perspective, the most frequent request is for obstetrical nurses, ER nurses, med-surg, and then long-term care. And we've also had quite a few requests for nurse practitioners and paramedics. In the medical realm, which I'm going to talk a little bit more about this afternoon, our most common request is for surgeons of all different varieties, orthopedic general surgeons, neurosurgeons, and then neurologists, also of all different areas of specialty, neuroradiology, surgery, neuropsychologists. And then we get urologists, OBGYNs, radiologists, GP, pediatricians, ophthalmologists, oncologists, and plastic surgeons. When you're working with healthcare professionals, it might first be helpful for you to understand a little bit about the general personality of healthcare professionals. According to the Myers-Briggs personality test, they represent 12% of the population, and they're known as providers. If you go with that, the qualities that they are proud of or have are exceptional resources for coping with stress, a very clear moral code, which guides both their own behavior and their expectations for other people's behavior. And this can make healthcare experts sometimes seem a little bit holier than thou, if you've ever had that experience, and perhaps judgmental of those who don't behave properly or according to their own moral code. Providers, that might be helpful for you to know, highly value their ability to be of service. They love to be part of the team, and they love to feel that they're helping someone do something. They value confidence in themselves, and the patients that they care for also value that confidence in them. They're interested in people. They're very snoopy. They love to share knowledge. They're curious about intimate details of people's lives. We never mind walking up to a stranger in a store and saying, like, what happened to your face? And that's because we honestly want to know. And the most amazing thing is, more often than not, people will tell us exactly what happened to the face and the whole story. So it's important for us to work in accordance with our values, and it's also important for us to work with people who are supportive. We love a sense of cooperation and team environment. So when I talked to some of the experts a couple of years ago, I got these comments about their desire for a sense of teamwork. A nurse said to me, let us help right up front. And this is talking to lawyers, just so you know. Let us help you right up front and give you the information you need as you take the case forward in terms of standard of care, the policies and procedures that we need to know. Another nurse says, I really appreciate a sense that I'm an important part of what's going on. As the case takes its time to work its way through the system, I would love to receive updates on when a decision is reached, why decisions are reached, what the outcomes are. And I'd also really appreciate a post-mortem interview with a lawyer to discuss my contribution and his or her satisfaction with the assistance I provided. An obstetrician said, I like to be involved in a case before examination, before discovery, because there are many times that I think, hey, you didn't ask those questions that I needed to know. The motivation for healthcare experts to work as an expert in litigation can stem both from their desire to help and support, their desire to support their own moral code. And I think it's fair to say that all of us recognize that we work within an incredibly flawed system, and we understand that there are just a handful of ways that we can advocate for change in the healthcare. And a physician expert said this very well here. He said, frankly, it was flattering to be considered an expert among my peers, and it's one way of promoting excellence in our terribly flawed healthcare system. So there's just a little bit of background about experts, the way they work and why they work. And now let's move on to talking a little bit about the different types of experts. I have this slide here that'll just keep you busy if what I say is boring, but this was from a medical website, and it talks about, you know, for instance, look at the top left. It says the crazy people will go into psychiatry and emergency medicine. There is a recognition within healthcare that different personalities are better suited and have very different psychological angles from other words. So for instance, let's talk about working with surgical specialties. There's a study published in the Journal of Royal College of Surgeons a few years ago that found that surgeons valued above all else their skill at operating. They also value their mental skill, and they also showed a high degree of motivation, confidence, concentration, and mental readiness. The things that caused them great stress and were viewed as having a negative impact on their work were distraction, noise, and any sense of feeling that they were being pushed or rushed. They're not always great working directly with people. Many surgeons I've talked to said seeing patients in their office are just a necessary evil so that they can get them into the operating room and open them up and fix them. Here's one of the favorite pieces of feedback I've ever received from a surgeon on how best to work with them. He said, dealing with surgeons is problematic at the best of times, since most of us are megalomaniacal prima donnas who love nothing more than to have our egos stroked. That said, we all live in morbid fear of being sued, a real but very misunderstood risk. Those of us who have done medical legal work have a bit less fear of the judicial system and do so that we can learn for our own accord. Surgeons will tell you that it's a lifelong process to become a good surgeon. They work forever and don't always know what they're doing. There's a great book on this by Atul Gawande called A Surgeon's Note on an Imperfect Science. They are, however, very comfortable being the leader of a team, even when they're lacking confidence in what's going on. And they are also very good at accepting full responsibility for outcomes. They must also make quick decisions in the absence of complete information. But they find it extremely rewarding to fix and see the impact of their actions. They like immediate results, and they will measure their success and their accomplishments through improved life and the skill of the surgical team. So a little bit of insight into that to get the best out of your surgeon. Keep the information direct and focused, calm. Too much noise bothers them. Try to give them as much time as possible. Don't let them jump to a snap conclusion before they have all the information, because that is just a part of their day, as it is with many acute care physicians. Appeal to their desire to help and fix and improve. Engage them where you can in a way that makes them feel part of your team, especially if you can put them in charge of something. And so whenever you can, also give them lots and lots of time to do their work, or let them be a leader, as I said, because they find great joy and satisfaction in helping you fix or solve a problem that you're struggling with. Now I'll move on quickly to obstetricians and gynecologists. The psychology behind the types of men in particular that go into this area of expertise can get a little strange, I'll tell you. Women's medicine is thought to be in a category all of its own. And some psychologists believe that OBGYNs have a need to enter into the mysteries of the female nature, as it were. However, considering that the practice of medicine grants a specific power of sorts, and I'm going to put that in quotation marks, it's also been said that both men and women who enter into obstetrics make use of this specialty as a way of exerting power over the female. But that's all I'm going to say about that, and I'll just let you have your own thoughts and conclusions about that issue. That's the psychology behind it. The general culture of working in obstetrics is described as fast-paced, diverse, joyful, hard work, difficult when the outcome doesn't happen as anticipated, but also quite longitudinal. Obstetricians will sometimes take care of the patients for months or even years. And one obstetrician said, not only do you get to deliver babies, you also get to do surgery, which was kind of exciting to them. They're self-evaluating. They can be narcissistic risk takers. They are another group of medical professionals who have to often make a very quick decision without all the information at hand. Emergencies happen on a regular basis, and decisions are made on the best available people and information in the room at the time. They can be very negative in their self-evaluation when things go wrong. They can be persuasive. They like to work with not a lot of rules, not a lot of regulations. They can be arrogant. This isn't me speaking. I want you to know this is research. Arrogant, entitled, self-important people who love admiration. And they're used to a tremendous amount of gratitude. I mean, there's almost nothing in the world more satisfying than delivering a beautiful, healthy baby to a couple who's waited a long time. And there's extreme and immediate feedback and gratitude for the hard work that they do in most situations. At the same time, on top of being egotistical and difficult to work with, they can be incredibly accepting of the personal input that comes with the labor and delivery. I've sat in a room with many, many obstetricians as they patiently sat, trying hard not to let their eyes roll backwards in their head while they rub scented lavender oil on someone's perineum during the second stage of labor, or suffer through hours of Zamfir pan music in the background during the entirety of the labor and delivery. And often thought, you know, God bless you for the work that you're doing, because not only is it hard, it comes with a lot of expectations for a perfect birth and delivery. I talked to one obstetrician who does work for both plaintiff and defense lawyers, who described himself like this. He said, really, we're just kinder, gentler versions of surgeons. But we have a tough job of asking people to make really big, important life decisions without having much information. This leaves most of us feeling really uncomfortable. So as obstetricians, we have to be very pragmatic and be able to just sit with the fact that sometimes people, including ourselves, make really bad decisions. And sometimes our decisions don't lead to the best outcomes. So when dealing with obstetricians, don't talk to them about their birth story or their mother, but do stroke their egos a little bit. They work better when they're feeling positive about life. You might find that you have to make them go back and reread information more carefully, because they may not have considered all the facts or all the details of the facts. Because as I said, they're used to making snap decisions on incomplete information and moving beyond that, just moving forward. Understand where you can their need to feel somewhat self-important. Give them lots of room to work, but never be afraid to question their judgment. They're used to some feedback, and you can persuade. Appeal to their sense of wanting the right outcome for everybody, and say thanks. Say thanks to them a lot, because they're used to that and they appreciate hearing that. Now, moving on to neurologists. It used to be said of neurologists that they saw the patients only twice, once to make a diagnosis and a second time to tell them there was no treatment. Happily, things are changing, but it is definitely an area of medical expertise where diagnostic capability still outstrips treatment capability. Neurologists work with a long list of essentially untreatable diseases like ALS, multiple sclerosis, catastrophic brain injury, stroke. As a specialty, it's considered a brainy one, and where they get to play with the most expensive toys, quote unquote. It's a complicated subject, a complicated area of medicine. And people who are attracted to neurology are generally very challenged by clinical and academic work. Difficult diagnosis, despite all the developments in technology, as I said, careful diagnosis and management will hinge on clinical assessment, a thorough history, the patient examination. Their levels of skill and communication are sometimes good, sometimes not good. They may not always be a natural part of their personality to be warm and empathetic, but they will be someone who loves the science and the research behind the disease. Neurologists describe themselves as some of the most unhappy of the medical professions. They're tied with gastroenterologists and just barely above internists on the happiness scale. They list reading as one of their favorite activities, which makes them very attuned to medical legal work. They stay married to their first wife longer than any other kinds of doctors. They're very moderate in everything they do. They dress moderately. A lot of them drive Toyotas. They can be reasonably good at social media and communication. So when dealing with neurologists, just know that they like more detail, and they'll find the challenge of reading through and sorting out the case a great part of the fun. They are, without a doubt, the most likely expert to spend the most time reviewing a difficult case only to phone you and tell you you don't have a case. And that will be a much easier thing for them to do than any other type of expert. They're most likely to say there's nothing else that could have been done, or the outcome wouldn't have been anything different. So don't be afraid in this situation to explain and present legal arguments and logic that may be opposite to what they have just told you, because they're comfortable there. Moving on to ER docs. Working in the emergency department involves interacting with lots of people, including anxious patients, difficult relatives, nursing staff, junior doctors, ambulance crews, police. It's a very challenging job, and they, like other experts, are used to working very quickly with less than perfect information, and in many cases, they're almost anonymous. You might visit an ER and have a very meaningful encounter with them that saves your life in one way or another, and never know the name of your doctor. Perhaps for this reason, ER docs count themselves as one of the happiest group of physicians. They say that they're the best of all the medical specialties to sit down and have a beer because they're good at very intense short-term relationships. Then they always have great stories to tell. ER doctors also describe themselves as having a high level of emotional intelligence. There is no other job in medicine where in 1 minute you might have to tell a 50-year-old woman that her husband has just died of a heart attack, and in the next moment deal with a young mother whose baby has a slight fever. They describe themselves as inventive, efficient, energetic, friendly, and confident. Overly compassionate doctors will burn out. Overly cautious and neurotic doctors don't do well in this job at all. People who are thin-skinned and disorganized will just stand up, maybe crying in the bathroom. They can, however, according to some research, be the most biased of all doctors. They might make a snap judgment based on the short version of the story, appearance, on gender, on race. They may have an overconfidence bias where they think, I'm relying on my intuition. I know this, I got this, rather than looking at the facts and the details in the medical records. They might also be the first to accept a previous doctor's findings without adding too much skepticism or critical thinking. And they might also have a sort of an availability bias, thinking, I saw someone recently or who had similar symptoms, and just make a judgment on what's gone on. So these mental miscues can be stronger when they're correct diagnosis. The diagnosis is a rare one, but it's good to know that about them and just continually question and make them go back to the medical record and not rely on their gut and their instincts, but to rely on the facts. So when working with ER doctors, chat them up, befriend them, take them for a beer if you can. I don't know how professional or ethical or likely that is, but they like, again, to be part of a team, and they like to be respected for their knowledge. Present your case as if it's the most interesting case in the world, because that's the stuff that sparks their fire. Tell them you could really use their help. Ask them, use words like, would you have a quick look at this and tell me if you can figure it out, because that's part of their every single day challenge. But don't let them jump to snap decisions or come up with an opinion based on small pieces of information. You can be very frank with them in your discussion, point out things that you think they've missed. They're relatively thick-skinned as far as doctors in the world go. Now, when working with nurses, nurses share a lot of characteristics. They're loyal and respectful, frequently the one who keeps things running behind the scenes. Lots of patient contact in almost every situation, but it can be very structured, and nurses can get stuck in routines. They work in large, stable organizations with a clear hierarchy and lots of rules, and their work is generally less prominent than physicians. They like the fact that there's right and wrong, and they quickly learn what works and doesn't work. And sometimes that even means, as you will see in medical malpractice lawsuits or negligence suits against nurses, They do the wrong thing for what they think is the right reason. They like factual here and now information as opposed to distant theory. They like to be liked. They love to be part of a team. They love to be helpful. They have a strong sense of duty. So when working with nurses, keep things direct. Stay away from grand theoretical ideas and lots of legalese, but at the same time, take advantage of their strong desire to help you, to do things right, and their sense of teamwork by making them feel a part of the team where and when you can. Tell them you appreciate them, help them overcome any of the great fears that all medical experts have of being sued themselves. So the fear of working with you might bring up that fear, or the fear of looking dumb, the fear of asking questions. The first lawyer I ever worked with, I was personally petrified as a new expert, and the very first thing he said to me is, I don't need you to know anything at all about the law. I know the law. What I want you to know is what it's like to be a nurse in this situation. This kind of reassurance might work for doctors and nurses alike. And you might have to fight a little bit to overcome their sense of this is how we do it, and get them to look at alternate ways and the actual standards of care that are applicable to every different situation. So I'm sure my time is almost up. I could talk about this for days, as you can imagine. But I think what healthcare experts share with lawyers above everything else is a sense of we want to be prepared. We are used to being in control in our world, and moving our expertise into the legal world takes us right outside of our area of knowledge and comfort. So I hope, in recapping, that it is, of course, difficult to peg people into any particular slot, but I hope we've offered a little bit of insight into the psyche and personalities of some healthcare experts that might be helpful to you in finding ways to work with them and encouraging them to do their best work for you, recognizing that they're busy professionals, but they want to do well, and they love to be part of a team, and they love a nice little pat on the back once in a while because they're used to seeing immediate results and getting positive feedback on the work that they've done. And on that note, I'll bring my presentation to a close. Thank you so much for listening. I am more than happy to answer any questions, and I appreciate the opportunity to share these ideas with you.
Thanks, Chris. That was an amazing presentation. It actually made me think about when I was an articling student, we did a medical malpractice trial in Kingston, and the emerge doc was cross-examined vigorously all day. And the first thing he wanted to do when he got off the stand was to go have a beer. So we all went and had a beer with him. And so I was thinking, I know, and so this is almost 14 years ago, and I still stay in touch with him. He's such a nice guy. I still consult with him. He's one of my go-to emerge docs, and I see like the personality Tracy talked about, the neurologist, the emerge doc. It's true. It's just true. And I've made it a practice, and this kind of leads into a question I have for you. I've made it a practice to try to be, encouraging to the experts and friendly with them. And so I have a question for you, an etiquette question. Because
yes.
when I'm talking to a doctor, should I say Dr. Smith, or can I call them by their first name? And at what point can you kind of transition from, to a more informal discussion, or should you always be very formal with doctors? What do you think?
Well, I'll tell you, partly because I've been a nurse my entire life, and maybe partly because of professional courtesy, I typically stick with doctor unless they instruct me otherwise. If they say, please call me Bob, then I'm happy to. Or in my communications back and forth with them, if they start signing their name as Bob or TJ or whatever the case is, right. I might venture there. But I think mostly when working them in this medical legal realm, I would stick to doctor most of the time, and I think they appreciate that, and they're very used to that. But in a social realm, of course, I wouldn't do that. But that's my practice anyway, Paul.
No, I think that's good. I tried to. I was actually representing a doctor in a case, and he was wanting to see all the correspondence I had with the expert, and he saw that I was going back and forth on a first name basis, and he was actually kind of shocked about it. He's like, well, I can't believe you're doing that. I'm like, well, he started it. You do kind of want to get that relationship a little bit stronger. I find using the word doctor can sometimes put up a barrier or something. I don't know, maybe it's just me, but I think that I just try to dispense with that if I think it's appropriate.
Sure. Well, can I ask you something on the reverse side of that? Because a doctor asked me that question recently. Would you prefer to always be called Mr. Cahill, or are you happy to be called by your first name? I guess because they want to know that same exact answer.
Right. I think it's a personal thing. Absolutely do not call me Mr. Cahill. I don't like it. And I tell people that, I tell clients that, I tell people that I work, like I don't like that formality, but that's just me. I'm more of an informal person. I think it's an age thing, I would say. Like I know some, more senior lawyers expect that a little bit more of the formality, but I think younger lawyers, and I think just the next generation of lawyers, so much more informal. I mean, they use emoticons to talk to experts. You know what I mean? Like,
right.
So I think it's just a different standard as people change. I have one more question for you though. Why do the doctors charge more for the plaintiff reports? Why do you think that is?
I mean, I don't know exactly how to answer that. It may be as simple as because they can, or because they speak with their colleagues and sort of sort out what other people are charging.
Right.
I don't, and I'll tell you because sometimes doctors who are new to work and new to medical legal work, and we're often having to find brand new experts depending on the particular case to find someone with the expertise, and they'll come to us and say, how much should I charge for this? I don't even know. Right. And we always start them, we say the CMPA rate is right now roughly $3.75 an hour. Mm-hmm. And sometimes they'll say, okay. And sometimes they'll come back and say, okay, my rate's $4.50. And so I've never had that conversation with them, but I'm assuming it comes from discussion with their colleagues or something that they're comfortable with. Other doctors too charge exorbitant rates, even by anybody's standard, not but by anybody's
like $1,000 an hour or something.
Yeah, we even had someone not too long ago to charge $1,500, and he said $1,500 an hour, and he said, listen, if I'm going to do this, I'm going to have to put other things aside, and it just simply needs to be worth my time.
Yeah.
And that's all there is to it. And so, there's this, very direct answer for why the charge was that. But I could try to find that out for you. I can start asking them, like, how are you setting your fees? Yeah. And then they often give themselves a little raise every year. So
they do. And they probably don't. They don't do a lot of this type of work, and I get it that they want to make it worth their while. I often try to push the CMPA rate because it's lower. It sounds fair.
Yes, of course.
But the more savvy ones will be like, no, I'll charge you $600. So.
Sure.